And some of the activities this week, for instance, yesterday, we had a public speaking competition with high schoolers, and they were fabulous. And their topic was, Mother has, Father has, blessed be the child who has his own. Is generational wealth creating a legacy or just a sense of entitlement? And they were fabulous. They introduced so many different topics. They looked at it from all angles. And we are proud to say the winner came out as the Dominica Grammar School. They won for the second time. Second consecutive time they won that competition. So the teenagers were really, really good yesterday. The only regret I can say is that there were no young men among the competitors, all female. But hopefully we will address that in the future. And then we're having a continuing legal education session as well among lawyers, and we're going to focus on probates, legislative administration, estates. So this is all part of the topic that we are focusing on. Tonight, we're looking at copyright in music. How does that fit into our theme? Because copyright in music is property. It's intellectual property. And it is property that you need to secure for future generations. It's property that you need to make money from. It's property. A lot of people don't see it that way as that is my legacy, what I am creating for the future. So we thought tonight, and also some of the artists asked us, please address this issue of copyright. What on earth is it? They do get some exposure sometimes, but we wanted to do it for them, give them a refresher for those who didn't know, give them the information. So here we are tonight on this, and we're thankful that you have joined us. I want to ask you to sit back, listen. We're having a nice discussion, I believe, and afterwards, hopefully, we will have a little time for your questions also. Members of the executive, have I forgotten anything? Did we create legacy on Saturday when we beat the police in basketball? That's good. We beat them in rounders. We had a friendly competition, sports day with the police on Saturday. That's how we started off. We did go to church as well on Sunday, but on Saturday we had a friendly competition with the police, and the police pounded us in cricket. Despite our best efforts, Lennox Lawrence bowled a few, but you know, we were pounded. But we did better in basketball, we did better in rounders, we did better in dominoes. We had a draw in dominoes, thanks to Miss Luke and myself. So, welcome, sit back and enjoy. Let us begin, as we always do, with a word of prayer, and I will call on Mrs. Gina Abraham Thomas to lead us in prayer. Can we all stand, please?
Lord, we thank you for your favor on our lives and for bringing us all safely here today. We thank you for those who have planned and executed this timely event. We ask that you bless the panelists, everyone listening and participating this evening. We ask that you give wisdom to the speakers. Let their words be clear, honest, helpful, and genuine. Give understanding to the audience. May they listen well and learn. We ask that you remove pride, bias, and fear, and that you replace them with integrity, knowledge, respect, truth, clarity, and unity. May this discussion bring insight, solve problems, build community, and legacy. Guide every question and answer. Let your peace, wisdom, knowledge be over this room and everyone present. Father, we ask that you continue to bless the work of the Dominica Bar Association and its members who continue to volunteer their time, talent, and treasure for the betterment and growth of our society. We ask that you increase those in this industry and that you may continue to build graciously that they may continue to build graciously for themselves, for their family, and for this nation. In Jesus' name we pray, amen. Amen.
I should have asked you to please remain standing. Apologies. We will call on Ms. Danielle Wilson, who will lead us in the national anthem. All stanzas. Isle of beauty, isle of splendor, isle too also sweet and fair. All must surely gaze in wonder at thy reminded, I always forget to introduce myself. I apologize. I am Noelis Knightley, the president of the Bar Association. So I am going to call now on Miss Carlita Abraham. We're going to get right into it. Miss Carlita Benjamin. I think my mind is still on the prayer of Miss Abraham Thomas. Or I might be foretelling something. I don't know. So Ms. Carlita Benjamin, attorney at law, is going to be our moderator for this evening, and I will hand over to her now, she's going to introduce the topic and the panelists.
Seeing as I'm already in my place, and I want this to be a very comfortable discussion for our panelists, I will introduce them from the seats, and I will also I'll give you some of the house rules for this discussion, and I'll encourage everybody to listen with an open mind, and any questions, we will deal with them at the end. But first off, let me thank the panelists for answering to the call. With the Dominica Bar Association, we have been looking forward to dealing with a topic that deals with legacy for this week, yes, but also legacy with our music. The Bouyon music has hit the scene in many different ways, and though it's not one of our first music originating from the Commonwealth of Dominica, it is one of the genres that is now bringing a lot of eyes on the Commonwealth of Dominica. And we are taking this opportunity as the Bar Association to gather some of the faces that are more popular in the music business right now, some of the legal minds who will be guiding us actually on the difference between music and the music business, or the importance of music business, and understanding your intellectual property rights as a musical artist. And of course, we have with us virtually one of our very own princess of song, if I can say, Ms. Mikel Henderson. So, allow me to introduce you to the topic. Our topic that we'll be discussing this afternoon is protecting your song, the legacy of Bouyon and other musical art forms through the protection of artists' intellectual property rights. And with us, we have the Registrar of Companies and Intellectual Property. To my left, Ms. Athlin Nesty. We have Mr. Sheldon Shelley Alfred, musical artist and lead singer of the Signal Band, as well as Gail John Baptist, stage name Trilogy, musical artist, and of course, Miss Mikel Henderson. Now, without further ado, I'm going to get into giving you a bit of their background, giving you some of an introduction for those of you who are not that intimately familiar with their background and the reasons why they are sitting here this afternoon on our panel. Our first panelist, Ms. Athlin Nesty, needs very little introduction to those of us in the legal fraternity and those of us that have been engaging in the commercial landscape of Dominica. Ms. Athlin Nesty is an attorney at law with over 14 years of legal experience. She holds a Bachelor of Laws degree from the University of London, a legal education certificate from the Hewden Law School, a master's degree in commercial and corporate law from the University of London with specialization in advanced contract law, corporate governance, and she is as well known, she's specialized in advanced corporate law, corporate governance and compliance, corporate management, and finance, and intellectual and industrial property. She has quite a basket of knowledge, academic knowledge especially in the field of corporate law and intellectual property. She currently serves as the Registrar of Companies and Intellectual Property for the Commonwealth of Dominica and brings over 7 years' experience within the corporate and intellectual property sector. She also serves as a legal consultant, as a CFATF legal advisor, and sits on the core technical committee of this OECD and the CFATF working group of Dominica, contributing to regionally and international efforts in regulatory compliance, governance, and legal reform, and as Dominica's national focal point and representative to the World Intellectual Property Organization. That is a mouthful. And I still have more. At the center of Miss Nestie's professional philosophy is a deep commitment to God, most important, a deep commitment to country, and the service of the people of Dominica. She firmly believes that no nation can achieve sustainable growth or true economic independence without strong businesses, innovation, and a robust intellectual property framework that protects creativity, enterprise, and investment. Her office and responsibilities sit at the very heart of the legal and commercial architecture. And as an attorney at law, Ms. Nestie brings not only the authority of her office as registrar, but also analytical rigor, clarity, practical insight that comes from years of legal practice, certification, training, and experience. She's uniquely positioned, not only to my left, but uniquely positioned overall for Dominica's artists, creators, entrepreneurs, and the wider public. Ms. Nestie, I can say, after saying all of this, I am truly honored that you are sitting to my left and you are able to guide this discussion on intellectual property and to also assist and guide our artists. I'm also going to introduce our beloved Sheldon. Shelley, the music designer. He was born in Goodwill, Dominica, on the 1st of September 1995, and he is a multifaceted artist, songwriter, musician, and designer. He's the CEO and co-founder and lead artist of the Signal Band, one of Dominica's most prominent Bouyon groups. Shelley's musical journey began at the age of 12 under the stage name The Professor, when he entered the Junior Calypso Monarch competition, for those of us who remember young Shelley. He quickly rose to prominence, winning 3 consecutive crowns from the year 2009 to 2011. In 2015, he made his debut as the National Calypso Monarch competition as a first-year finalist and was crowned Stardom King of the 10th that year. Since then, Shelley has shifted his focus to Bouyon music, where he and the Signal Band have garnered widespread acclaim for their songwriting, for their composition, and of course for their dynamic performances. Shelley and the Signal Band have carved a unique niche in the Bouyon genre, fusing clever lyricism, smooth melodies, infectious rhythms, and more. They are celebrated for modern Bouyon classics such as On My Way, and my personal favorite, I'll Be There For You, and of course, Bye 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 to the Old Me, which recently surpassed 1 million views on YouTube. The band's discography includes a wide array of singles and 3 full-length albums, Signature, Controversy, and The Electric Room. Other fan favorites include Stronger, Make Her Ball, and collaborations such as We Ready and Rags with other regional and internationally known artists, and of course, his colleague to his left. In addition to his thriving music career, Shelley is deeply passionate about the synergy between music and design, often describing himself as a musical designer. Now, Shelley does modern music and has been doing modern music, as he holds an associate's degree in architecture from the Dominica State College, a Bachelor of Science in Architecture and Environmental Design from the Morgan State University, and a Master in Architecture from the Harvard University Graduate School of Design. So when he's not performing, Shelley spends some of his time nerding out on topics related to music business and architectural acoustics, blending his academic background with his musical intuition to explore the science and sound of space. Like I said, ladies and gentlemen, here, I want to impress on you how best these persons are suited to be sitting on the panel this evening. So you've heard about Ms. Nestie, you've heard about Mr. Shelley. And on the seat next to Mr. Shelley, we have our Mr. Trilogy. Allow me to pull up He's known as Gael John Baptist, better known as Trilogy. He is a Dominican musical artist who has made his mark on the local and regional scene with a sound that is bold, current, and unmistakably rooted in the culture of the Commonwealth of Dominica. He has brought Bouyon music all the way to the motherland in Africa, having performed recently in Ghana. And as an artist, he operates in an era that is shaped by social media, digital distribution, and rapid musical exchange. So Trilogy brings a contemporary perspective to the challenges of protecting creative work in the modern age. His experience in the music industry is a testament of the pace at which Bouyon is taking center stage in the world, and he retains his individualism, his well-known lyrical style, his ability to maintain partnerships through his own, regardless of his own physical battles, and he understands both the opportunities and risks that shape the digital landscape that all artists, at least all young artists in Dominica, are currently faced with. We want to welcome Trilogy, and before we give him a round of applause, again, I have quite a bit to say about these persons that are sitting on our panel. Mr. Trilogy was also Dominica's very own Calypso King of 2023. He won the Caribbean Music Soca Collaboration of the Year in year 2025. His Billboard #4 Album of the Year for the year 2025, and also Billboard Artist for the upcoming Caribbean Artist April 2026, among his many, many, many well-known regional collaborations. So Mr. Trilogy, we welcome you. And we look forward to your candor and everything that you have to share this evening. And finally, in the introductions, our very own Michael Henderson, who is joining us virtually as her musical talents have pulled her across the seas, and she is not physically able to join us here. But she has given us some of her energy and some of her time and her commitment to join us. Our fourth panelist is a musical artist whose voice and creative talent have earned her recognition within the Dominican musical community. Michael brings to this panel a perspective that is both personal, if I can say so, and artistic. The perspective of a woman navigating an industry where understanding your legal rights is not a luxury, but a necessity, having had her own personal experiences with protecting her sound and her sound recordings. Her presence here, though virtual, reflects a broader truth that intellectual property rights are not only a concern for established acts or major labels, they are a matter for every artist at every stage of their career. From the first song they write to the legacy that they leave behind. Bouyon or any other art form. Michael, we are delighted to have you with us this evening, and thank you very much for your time.
Thank you, Regina.
Okay, now I've given you the history of the persons that are sitting here before us. Do we feel as if they are qualified to educate us? All right. I'm going to get straight into it. And we have broken up our discussion into 4 main topics, and some questions which the panelists will be posed directly, and some which they will be sharing the answers for. But before we get into the questions, some housekeeping matters. All questions from everyone sitting in the audience will be taken at the end. We want to limit to about 4 to 5 questions after the panelists have had their discussions. And also note that we're on a time limit here. We have about an hour and a half to have this conversation. So I'm going to be as frank, and I'm going to try to make this as comfortable for panelists and as educational for the public. All right? You ready to start? Ms. Henderson?
Yes, ma'am.
Okay, good. In plain terms, we are dealing with copyright. We are dealing with the basics of copyright. What is it and what does it protect? In plain terms, Ms. Nestle, when exactly does copyright arise for musicians in the Commonwealth of Dominica? Is it when they write a song? Is it when they record the song? Or is it when they register the song? And I'm seeing register in quotation marks.
Okay, thank you. I would just be referring to a computer for some notes that I have compiled that give actors to legislative boards. You can hear me?
Yes, you just needed to bring the mic closer to your mouth.
It's better now.
Okay.
Okay. Thank you, Madam Moderator. Okay, so to be relatable and so that everybody understands, let's take the word copyright, and that's exactly what copyright is. It is the right to copy or the right to prevent someone from copying your work. So always place that to memory. It's the legal protection given to original creative works, and I will break down the elements. But first, if we have to understand copyright, let us understand it through the establishment of our Copyright Act. And our Copyright Act of Dominica defines copyright as a property right, which affords protection under the Copyright Act. It is a right in work, and for this panel discussion, it is a right in musical work. So the Act doesn't tell you exactly, and it breaks down that copyright is a right afforded under the Copyright Act, because you have many rights of protection under copyright. But remember, as I said before, copyright goes back to one, the legal protection given to original creative works. Now there are two elements: originality. Your work must be original. And there must be also a creative element in your work. And when you look at the learning, the courts have said that there must be a modicum of creativity. So it doesn't have to be extensive, but there must be a small, a moderate form of creativity and originality. And it must move into a tangible form, an expression, a fixed form, a recorded form. Because you cannot ordinarily accept that an idea in your head is to be protected. It must move to some fixed or tangible form. Now I know we are moving the theme of the panel discussion into Bouyon music. Now Bouyon music in and of itself is a genre, and you would see throughout the Copyright Act that genres are not usually protected in and of themselves. There's highly mention of melody throughout the entirety of the Copyright Act. Genre is a form of music that is understandable and recognized through over a period being considered that genre is Bouyon, and the public accepts that genre as Bouyon, but it's not a protective work in and of itself. Now, you asked of registration.
Yes, in quotation marks.
In quotation marks. Now, here comes my role as the registrar. I don't register copyright at all. Although we give prudence to the nations that have voluntary registration, yes, that is so. But that still doesn't evidence that work is yours. Copyright is created, is established from the time that it is created. So from the time you take that idea, your original idea is creative, and you put it in some tangible form, at that period it is created and established. So it is very important to understand that. And I know maybe the lawyers would know this process before, where in time long ago, people used to mail their work to themselves and not open it, because they felt that any time it was challenged, you would have a date. So you would say, listen, I have had this since this time. But still, does that establish originality? No. So that is why registration is not done.
It's not a term that we can say is used in copyright.
In Dominica.
In Dominica, you cannot register copyright.
Right. And I must tell our people, being such a patriot, and I see this all the time. And boy, I'm gonna copyright that. That is the number one thing that we see. As soon as we think of something, we say, boy, I'm going to copyright that. and I attribute that to mean I'm going to register that.
Yeah.
So just know once your original work is created and is tangible, it is yours.
Yeah.
It is established as yours, and you have that right to protect it from being copied and allow it to be copied later.
Okay, I can accept that definition for sure. So we are saying here that copywriting work is not necessarily the act of having it registered with the Intellectual Properties Office. It is the act of, or it is the act of having your sound or your music or your art affixed in some way, shape or form. Whether it's through a recording, whether it's through a video, whether it's in writing, what is the point? The moment that it becomes fixed, it becomes tangible, that is when your right is formed. Now, this question, sorry.
Core elements, originality, and creativity.
Originality, it has to be yours. It has to be yours in the sense that it's original. It was created by you. All right, and we tried our best. This is for the law week, and I do not want us to get too legalese or too technical with the terms. But sometimes, even if we are speaking about Bouyon and the panelists are all musicians, well, majority of the panelists are musicians, I just want to state for the record that copyright, yes, it is a property, but it also involves literary, dramatic, musical, and or artistic work, which also involves sound recording, films, broadcast, and so on. And all of this can be found in your Copyright Act that is on the Laws of Dominica website, chapter 7841. So for those of us who are viewing and just want to get some information from the direct source, from the legislation, we can refer you to the legislation itself. So we established here that the moment that a song is written, the moment that a song is recorded, or the moment that your art, your creative art, your original creative art is affixed to some tangible source, you have a copyright that is created. And I want to ask another question to you, Ms. Nesty, because we're starting off on the legal footing before we get into the experience of our other panelists. If you can tell me, what is the difference between owning copyright as composition, which is melody versus lyrics, versus owning copyright as a sound recording? And if you can make that distinction for us. If not, then I would love to pass it on to my artist.
Let me break it down, because you stress on owning copyright in different elements. If you are to create a song, there are two core elements that are created, that are established in copyright when you create music: your composition and your song recording. So from the time I start drafting this idea, I put my lyrics high, high. That's the basic tune, the lyrics, the... Wasn't good?
No. But we get where you're going. Okay. Your melody and your lyrics, okay. Yes.
You discern the words, the little chords, then you have established composition. That is one element in your creation of your music. And then there's the song recording, the final work, where you have recorded everything. And that is usually established as your masters. And that is where the core of everything is. They usually say, who owns the masters? Own the master. Because this person gives you the right to use it in an every way. But you still have that right in the composition that I have written my song. And I will forever, if that song is signed for, be the owner of that, and have the right to say, listen, you can sing it, you can do whatever you want with it, because that is my aspect of my composition, is mine. That is one copyright. Okay. So there are two elements of that copyright established. So the songwriter would normally, in most cases, relate to the composition, the words, the underlying melody, and the song recording includes the composition, everything, and the finished works. So that is basically those areas that's in creative music.
Okay.
Two elements of copyright in creative music.
Now, I want to bring in Professor Shelley here, just to give me his own understanding about not necessarily just the importance of owning, your copyright. Yes, we are established already that you cannot, once you create it, it's intrinsically, you become the owner in and of itself once you have fixed it. So it's not necessarily that you're trying to establish your copyright. It's already yours. But explain to me, if you can, the difference between owning composition, which is melody and lyrics, versus owning a song recording. If you can make that distinction for this panel.
Okay, good evening to everybody. So the two sides as Ms. Nesty reference is the composition side of the song and the master recording side. And the master recording, what I like to call the composition side is the truth of the song, meaning it's the reality of who wrote or who composed the song. When you say composition, that usually alludes to lyrics, authorship without even a melody, and then the melody, that's what brings the composition together.
Okay.
And then, so as I said, that's the truth. You cannot really lie about who did that. Like,
who wrote the song?
Where the originality, where the creativity comes from. Mm-hmm. When it comes to the sound master, the master, that can literally be anybody. Because that then becomes a conversation about finances and administration. Because I could literally come here today and say, Trilogy has a song, he owns the composition he wrote. He wrote the song, he has the melody, but I am going to pay somebody to produce the song, I'm going to pay a studio engineer, and I'm going to pay to market the song. I now own the master of that song. Trilogy owns the composition, but I own the master. And I can then choose if I want to give Trilogy some of the master ownership, or if I have to share it with anybody else based on some under-the-table deal we have, But usually the conversation of master ownership is very much, especially these days in music, is a financial conversation.
Yeah. So essentially you're saying the distinction is very important, understanding who created the lyrics and the melody, and then understanding the difference between that product versus what is usually considered a final product, which is the sound recording itself.
Yes.
They can be owned or managed by two different people.
Correct. And I want to introduce one term. The composition is interchangeably used as publishing.
Okay.
They call it publishing a lot, but that is still like the composition side of the music. Yeah.
Okay. And remember, we are all trying our best to be educated here, because we are not, we are legal persons. We can read the law, but we don't have the experience in the music business of being an artist and understanding for ourselves as musical artists the distinction between just because I put a few lines on that make that my song. That's not how it works. You are saying that there are different aspects of song recording or different aspects of the art of musical work that a person can own. But a composer or the author or the writer of the lyrics owns that.
No amount of money can buy that.
No amount of money can buy that. Yeah. Very well. And you can't, if that author wants to sell his right to it, that's fine, but we'll get to that later. Mr. Trilogy, and then Miss Mikhail will be coming to you soon after. From your own experience, Mr. Trilogy, at what point did copyright become real and personal to you as an artist? And I want to ask, whether or not there was any specific incident that made you sit up and pay attention, or was it a situation where you grew up in the music business? I'm straight to you, real and personal. Tell me, at what point did it become real to you as an artist, copyright? The term copyright.
Yeah, well, I think from the time, good afternoon, good night, good evening, everyone. Yeah, I'd say from the time I got introduced to music, right, as an artist, I was fortunate enough to have people in my corner, like my manager, Tridel and G. These are conversations that we had very early on in coming into the music scene, I would say. And, it's just observing certain things was happening in the music. I cannot really give an exact situation, because there are certain situations that happen that has been blown up. You understand? But really and truly, if you're in the music fraternity, trust me, there are a lot that has been going on before that. after that, during that, you know. So I mean, from a very early point, we had some serious conversations about copyright and just learning the music business, and how, you know, that can affect us and how we should navigate and this kind of thing.
So it's safe for me to say that you benefited from having a manager and having persons exposed to the music industry guide you and tell you.
Definitely, and to be honest, all of us would just get our feet wet in the music industry, like, you know, try to managing before that, but you know, when it comes to actually making serious moves in the thing, that's when we started our team and everything. That's when, you know, we really had to sit and pay attention, because some people would say that the Bouyon start taking off recently, but to be honest, it's been buzzing for a little while, and so it had forced us basically to get with the times, you know.
Get with the times, get with the education.
Because what ended up happening now, you have situations where people take advantage of you, you know, because they feel like you don't know what you're about and things like that. So we really had to sit down and
All right, and Shirley, and I'm coming to you to ask you about that as well, but I want to ask Ms. Michael Henderson, at what point from your experience did the term copyright started, was it a term, when did it become a term that you had to start using in your own music business and your own career, protecting your copyright? When did it become a term you had to start using as a wood in your career?
Good evening, ladies and gentlemen. Thank you for having me. Can you hear me clearly? Okay. So from the very onset, just like Gael mentioned, from the very onset of my career, I was fortunate to have had people around me who were very familiar and au courant with the subjects of copyright, including Gordon Henderson and many of the agents who I worked with in islands like Martinique and Guadeloupe, where for them, as soon as one enters the music industry, you are sort of initiated into the whole subject of rights ownership and administration. So it started from the very, very, very beginning, and I was indoctrinated quite early by people who were down in the trenches. So I started using it from day one, to be honest. But I just wanted to clarify something. I'm just before we gloss over it, that Shelley mentioned about publishing and composition. Just to clarify that composition and authorship vest squarely in the authors. The rights for those things, they vest squarely in the author and composer. What a publisher does is, a publisher is someone who makes that composition available for use, for exploitation. But to do that, he has to have some of the same rights that an owner has. Yeah. And so when you are an author-composer, you cede some of those rights to the publisher so that they become part owner. They become like an author, like a composer of the song themselves, for them to be able to administer it, because a lot of the administration involves dealing with the rights that only an owner can authorize. So that's the distinction, just so you know why it is that he would compare composition or authorship with publishing, just to make that political. Yeah.
Thank you very, very much for that. Because again, like I said, we are lawyers here, and the public are laypersons, but the business and the legalese and the technical jargon in the music industry and the music business is very important. And I think it's also very important that even if we're having this discussion tonight, that we continue researching and we continue investigating and trying to understand for ourselves what copyright is and how important it is. You know, especially as we are trying our best to secure the claim to the ownership of Bouyon music, if I can say it like that. But we'll discuss that later down in the discussion. All right. Another question to the panelists, yes, Ms. Nesty, Shelley, Triller, and Ms. Mikkel. How does a Dominican artist currently collect royalties when their music is played on the radio, at a bar, or in a fete, or streamed online. How does a Dominican artist basically collect money when their music is being played, not when they're performing it, when their music is being played on the radio, at a bar, in a fete, or streamed online? And I'm going to leave it to any one of them.
I can answer that very squarely if you want.
Please, Miguel, please. Let's go, Miguel. How does a Dominican artist currently collect?
Yes, because I'm a Dominican artist who gets paid for those kinds of things, so I think I would be okay to answer that question.
Thank you. Let's go. Talk to us. Let's go. I'm listening. We're listening.
So first of all, licensing is one of the major sources of income for copyright royalties. So what would have to happen initially is that a license would have to be issued to anybody who's using music, for example, a bar, a radio station, a venue, a promoter, and that license, the money is collected from the proceeds of that show. It's usually a percentage of the proceeds from the show. The license is paid to a collections management organization, because the Copyright Act or the copyright legislation literally gives the right to the author to authorize performance of their work. Now, if a show, a hotel, a bar has to go to each and every performer, it is completely impossible for you to do that. So that's why collective agencies exist, collective management organizations, exist, so that you can go to one place to get a license that would allow for the collection of these monies that are remitted to the CMOs, and the CMOs who consist of membership, musicians like myself, would be the ones to distribute those royalties out to their respective members. So, for example, when the World Creole Music Festival asks you or the musicians and Triller for a list of songs and composers and so on, it's so that when they pay the license, there is a list of music that was used at the venue. And so the royalties collected after administrative fees would be prorated based on the usage and the songs that are played there, and the people who are actually registered with the CMOs would collect that money.
Thank you.
So that is how the process.
Thank you for saying that last part, because that was my follow-up question. You said CMO, and just to clarify, CMO is the collective or the collections management organization. But how do they know to collect money for you?
But that's what I'm saying. I just explained. Everyone needs to be registered with a CMO.
So that is the point I wanted us to discuss. But to explain to us, how can they be registered? How do they get registered with a CMO?
How or why? Sorry, I didn't hear.
No, I understand the why, because they want to collect the money. But how can they get registered with the CM? And if I'm talking too quickly because of the internet connection, just let me know. I'm good?
No, you're good. It's just that sometimes there's a little echo on my end.
Sorry.
But it is very easy to register with the CMO. There are various CMOs all over the world that one can register with. In the Eastern Caribbean, the CMO that operates in our jurisdiction is ECHO. Eastern Caribbean, what is it again?
Collective.
Eastern
Caribbean Collective.
Ms. Nesty can correct me on that. But yeah, for some reason I just went blank on that. But ECHO is the one who functions in the Eastern Caribbean. There are other entities like Jamaica, SASEM is for the French, you have COT in Trinidad, and you have COSCAP in Barbados, etc. And all these agencies basically function as collective management organizations that collect money on behalf of their members. So you have to be a member of one of these societies for you to actually collect from them. Now I want to mention something in particular, because I know a lot of artists have heard of the ASCAPs and the BMIs, and those are the very popular CMOs, and would be willing or more inclined to join a major CMO like SASEM, BMI, and ASCAP. the thing that we need to understand in the Caribbean is that these entities do not collect in our region whatsoever. The only entities that collect in the region would be the Caribbean entities themselves. So, being a member of UWI is great, or ASCAP is great. Just know that they will not collect for you in the Caribbean, except ECHO collects for them, right? So they are not here presently physically in the region. So ECHO would be the one to collect in our Eastern Caribbean and then remit to them, because we have what we call reciprocal agreements amongst these agencies that allow one to collect for the other. So it is in your best interest to belong to your local agency. You can still belong to the international one, but what you have to do is separate the territories so that the local agency collects for you here locally in your region, and the international agency can collect for you all over the world.
All right.
So that's my...
And I know we've been on this question for a little while, but I just want you to just give a little more information. Who in the Commonwealth of Dominica can a person reach out to if they want to have themselves registered or become a member of ECHO?
I have helped several people. People can reach out to me as, I'm actually have 2 appointments when I get back to Dominica to sit with 2 interested persons who have asked me, and I've done it over and over again with several people. I do it for free. I'm not a lawyer yet, so I cannot charge for this thing, but I do it for free. I encourage people to call me, and I can help you through the registration process. And I don't benefit anything from it. It's really just so that we have a good collection. Everybody's on board with the idea of ensuring that collective management organizations are well supported, because I don't think artists understand what it is that a CMO does for them. And so you can call me. A lot of people have reached out to Mr. Murray. You can reach out to Mr. Murray as well, because he is an agent for ECHO. But you can also go online and find all of this information. It's available for free. You can find it. So if you're having issues deciphering for yourself or going through the websites, and then I can help. I have no problem with that. I'm offering my services to anybody.
Very well. And that is ECHO, ECCO, correct?
Yes.
Okay. And Ms. Nestle, I want you to weigh in on that a bit, because you might understand from your position as registrar the realities that come with registering with collective management agencies.
Well, not as registrar, because at the end of the day, remember, not as registrar, because remember, the IP office does not facilitate registration of copyrights. So the law in Dominica speaks of licensing. So in international standards is that these collective management organizations represent artists who place their license into their hands. So they become exactly what the term states, the collective management of the artist. So they ensure that they collect all your royalties for you. The benefits of these collective management organizations is that they have bilateral or multilateral arrangements with other collective management organizations as well, and their reach, because of that, goes far and beyond for collection. Now you asked a question as to the reality, how do the artists collect for radio, the bars, and the feds?
Yes.
Now that in itself, there's supposed to be structured procedures so that the collective management organizations themselves can ensure that what is owed and due is recorded and it is owed to the artist. So the radio stations, you're supposed to hold logs and various elements to say that I'm playing this, so that the collective management organization can see what is actually owed and the royalties that are due, because it's an income and it's a calculated venture. So there needs to be further public education with these entities so that our artists in and of themselves can obtain the rights and that income that they so designedly deserve. So for the bars and everything, and our collective management organizations in reality need to have more of a presence and a structure and an outreach so that our artists are fully aware of this is what I do, this is what you can get from me, and this is how beneficial I am to you. Not only that, but they're supposed to be aware of the calculative measures that you have in your organization to know that if I grant you this license, this is how you calculate. Is it on gate receipts, other things. So they're supposed to know how are you collecting royalties. So it's supposed to be a symbiotic relationship because I'm handing over my rights over to you.
The collective
so I need to be empowered with that. And they too are supposed to go and outreach to societies. So the radio stations will ensure that they have all these procedures. Okay. So it's a whole system of society that's supposed to be established so it works for the benefit of the artists.
So it's safe for me to say tonight that this is an appeal from the registrar for public education on music management. So, right?
Well, yes, and I say so because I would place on record that there is no regulations currently for CMOs, but they have developed regulations now in St. Kitts, which we were using as the model test country, and it was challenged when it was implemented. So all the OECSDs were waiting to see what the court held, whether or not these CMOs can be regulated so that you ensure that they do what they are supposed to do. And the court held that yes,
the artists can get their money.
That the IP offices are going to can regulate you. Okay. So in order to should I say cure that defect that I spoke about, the regulations were implemented. So St. Kitts is the module states, and I know it will be trickling down to the other OECS islands for implementation. So that is something new. And I must give kudos to ECHO as well. We had a meeting last week with WIPO, and there's this zeal and this energy to get back like on a strong footing and identity print in Dominica. Yeah. So I look forward to that, and I'm happy for the artists. As Mikel said, the preliminaries and reaching out to ECHO is important to get this basis before.
All right, so as it stands, Ms. Henderson and Mr. Mark Murray, who is currently sitting in the audience with us, they are the persons or the agents or the go-to persons to have your membership registration with ECHO so that the Dominican artists can start to figure out how to collect money from their music being played openly in the Commonwealth of Dominica or in the Eastern Caribbean. Now, we spend a lot of time, like I say, we are lawyers here, so my tendency is to gravitate towards the technicalities, but I need to speak on Bouyon as a distinct art form, and that's why I'm going to reach out to these two gentlemen to my left. And the topic is on collaboration and sampling. When an artist innovates within the genre, I need to know what exactly can they protect. Can they protect the beats? Can they protect the rhythm, if that is different from the beat? Can they protect the lyrics? Can they protect the arrangement? And Ms. Nesty said you can't really own the genre at all, but like I said, we'll discuss owning Bouyon later on. Can the artist protect the beat, rhythm, lyrics, or the arrangement? Talk to me about that, Mr. Shelley. When an artist innovates within the Bouyon genre, what exactly can they protect?
I mean, you can protect anything that is original and creative.
Right.
So as long as that innovation that we're speaking of is original and creative, then you can protect it. And obviously, like words like originality become subjective. Like people interpret that how they want. But like, from a musician's standpoint, you cannot protect a chord progression. Like, the chord progressions have been there. We speak about 1-4-5, and when you do music theory, you understand that they are popular music progressions. They are progressions that evoke a certain emotion that artists use over and over. Yeah. And that doesn't make my use of it now be unoriginal. What will establish my originality is how I sing my melody and how I attack my lyrics on that progression, and which then makes the work itself original. So it's still going to come back down to originality and creativity. Yeah.
So the main frame is
So that and I works for beat makers and all of that as well.
Okay, so lyrics, beats, rhythms, arrangement. All right, so you can protect it once you created it.
Yes.
All right. And now Bouyon is rooted in the culture of Dominica. We identify with it as patriots, as Dominicans. And for those of us in the audience, even myself as a moderator, who may be less familiar, Mr. Trilogy, can you describe what makes Bouyon unique as a musical art form? What makes Bouyon unique? In fact, let me make it to you. Let me ask you that question. What makes Bouyon music as an art form unique to you, as opposed to, let's say, soca?
Please don't screen record this. Nobody.
Please don't put this on TikTok. Yeah, to me, I like the fact that you address it to me, so I can give you what I feel that makes Bouyon so distinct. You know, as with any genre, you know, and I have notes to it. I can
pull up your notes. Yeah.
And the form, and then the audience expectations and tropes. So there's 3 different, I'd say, categories that would make you identify what a genre is. So that is the long version of it for me now. And that goes back to the point number 2, stylistic, technique, and form is the drums. If you change, and you can do that little trick for yourself, if you change the drums of any chord progression, like my partner said, you get in a different genre. So if you have, give me a tune now, give me something. Freestyle. No, not drums. Just hum something for me.
Give the mic.
That is like kind of soca, China soca. And then you have. Are you feeling there? What are you hearing there?
Iron Fist.
No. Genre. What genre are you in there? That's Bouyon, come on now, man. That's Bouyon. No, I can continue. I can do the rhythm. You're just doing that, and give me the reggae. So you see, once you change the drums, you can get the different genres, right? So that is why I believe Bouyon music should be considered a genre of music, because it is so distinct that there's no other music that you can take and put the rhythm, the drums, and it will sound like it. You understand?
Understood. So, thank you very much for that answer. And I love the fact that you brought in some examples, because like I say, and I'm going to see this almost every topic, we are lawyers here. So we want to be educated about what makes Bouyon Bouyon and how we can identify or claim it as our music as Dominicans. But like I said, we'll get to that discussion at the end. When artists collaborate, and again, this is a question for everybody. Ms. Mikel, I would love to have your personal experience on that. But I'm also starting off with the 2 gentlemen that just answered. When artists collaborate without a written agreement, can any of you tell me what the law presumes about the ownership and how you split those royalties? Another hard question, but it's a real question for our panelists. When artists collaborate without a written agreement, what does the law presume about your ownership and royalty split?
I'll start because
Yes.
the mic is really close to my mouth already. I'm here to also learn and be corrected.
Yes.
And I say that because in the events that I have collaborated without a written agreement, there has always been a verbal one. So at least there's some form, so I know there's an understanding between myself and the artist. And thankfully, I haven't been in any drama, where that is concerned. I think the law, I want to be corrected.
Yeah.
I think it assumes that it will be split equally if there is no agreement. But
Okay.
that is my thinking.
That's your thinking. All right. Trilogy, let's jump straight to you. Tell me what is your thinking and try to tell it to me in a sentence or two. What is your thinking when there is no written agreement, right? how do you split the ownership of that music?
Okay. Ideally, it would be great to have written agreements.
Yes.
But again, like Shirley say, a lot of the times you have verbal agreements.
Yes.
Between different people when you collaborate.
Yeah.
And sometimes it's like once you see you have that verbal agreement, everything should go smooth once everybody understands their roles. Like you understand what you put in, and you understand what you're going to get from that. And myself and Shelley have collaborated on numerous projects, and what they like to do, no issue, no reject. So I just feel like it's just a method of just understanding and making things clear as to
In your agreement.
what who gets what happened in there.
No, I ask you all because, and I started off with you all because you all are the artists, and I wanted to gauge exactly, legally what your understanding is. But Miss Michael, I'm going to send that question your way because I'm looking for a particular answer. All right.
Okay, Miss.
I'm not saying that they're wrong. I am not saying that they're wrong.
Okay, Miss.
But I'm looking for a particular answer. When artists collaborate without a written agreement, what does the law presume about the ownership and the royalty splits? And we can ownership, royalty splits. Tell me.
Wow. Okay. So, I cannot speak to the letter of the law.
That's fine.
Where the statute says.
Yes. Speak to the spirit. Speak to the spirit of the law. Then.
So the spirit of the law, even in reference to the statute, every creator who contributes to the work is considered a contributor. Now, I hear reference to equal parts, but that's not necessarily what happens in every jurisdiction. There are some jurisdictions that actually specify that if you collaborate in a work, that the work would be split equally amongst the collaborators. That does not apply universally. So in Dominica, the Dominican context, I would have to review what the statute says basically about that. But it stands to reason that if someone contributes maybe a more significant portion or plays a bigger role, that person might be considered to be a bigger partner or someone to have a larger share in the whole work, right?
Yes.
However, as Trilogy said, is right, we should make good friends with a particular tool called a split sheet. This is a standard in the music industry. Split sheets are standard in the music industry. Whenever you create a song, the best thing to do is to use one of those sheets. You can customize it to what you want.
Say that again slowly for us. What, a split sheet?
Split, yes.
Okay.
And that split sheet has all the information concerning the song. It will have the what you call metadata about the song, who owns what, it will say, and in what portion. Also, a split sheet would, if we use those tools ahead of any publication of any song, then we would avoid many of the pitfalls that we've seen happening time and time again with verbal agreements. Verbal agreements are great amongst friends, but friendships sometimes deteriorate, sometimes, you never know what happens. Things happen. So it is better, it's safer to use a split sheet that says the name of the song, the title, the length, the metronomic measurement. It says who owns what, who is the producer, what percentage of that recording is he going to keep, who are the authors, composers, what percentage is each person going to, and everyone needs to agree and everyone needs to sign that split sheet, everyone gets a copy of it, and your collections management organization gets a copy of that too.
Noted.
Or you can input that data into their database so that they are aware.
So, coming off of this question, we see here that it's our practice to have verbal agreements, but we are encouraging persons to reduce things to writing. And this is where the lawyers activate. We like agreements, we like them in writing, we like to understand who is getting what share, right? And so what Ms. Henderson has just said there is that the split sheet will or should make all of that simpler and easier for you and easier for the artist to track when it comes to collecting on their investment in that, or that, on their collaboration in that song or in that work.
Correct. Just another thing I'd like to mention, even like I work with a distributor called Believe Digital. And they even allow you, and that's for digital distribution, so they collect monies on the internet, on YouTube and everything for you. And they allow you to enter your split sheet data as soon as you're uploading the song, so that when they do payments directly to the people on the splits. They don't even have to send it to you and then you have to remit to the people you agreed to remit to. They can actually do the splits for you. So it's becoming easier and easier to actually just do the right thing. We just have to get into the habit, the culture of doing it.
Or getting informed. And again,
Yes.
that is the purpose of the Dominica Bar Association celebrating its Law Week and choosing this theme. Protecting our legacy, and especially in relation as it is to this growing genre, Bouyon. Now sampling. Yes, Madam Rich.
I think you have the musicians, the elements of law, but in order to establish proper procedure and focus, and I know the split sheets is something that is quick and easy and there in case you are not into formal agreements and you and your friends are working and you can just pull it out and it gives that reduction to writing of your intention of your work. But as lawyers, for music and the entertainment industry, there are a lot of elements that you must consider when you are creating agreements for artists. It is not only on the percentage share, although economic rights is also important, there are many other rights that you need to consider. Because in creating agreements, you have to know that, listen, I have to look at the elements of moral rights, the elements of performance rights, the elements of derivative works, the elements of publishing, all these things. So it's nice and easy for us to reduce and create an agreement, but an entertainment artist agreement has to establish all these protective measures, because yes, it will give the economic shares of the work, but it still wouldn't stop an artist from the right to stop you if he does not feel that you are not embarking upon the moral rights. So there are a lot of elements that if you are going to enter into agreements with other artists formally, that you think of all these things and have these core elements enshrined in the corporate established, not only just the split sheets. I mean, follow the split sheets if you and your friends lime in and we create a song and you know it's going to be...
You need ban house and you want
yes,
to just
have it
something.
there all the time.
Yeah.
But if you know that, let's do this right, guys, we're going to have to sit down before you release the song and establish all these core elements.
I see that Ms. Henderson wants to just weigh in a little bit on that point, and something, and also Mr. Trilogy. We used that term a while ago, and I don't want it to pass over in juice. We use the term moral rights. Moral rights. So, Mr. Henderson, I'm hoping that is what you're going to just touch on briefly for us, and explain to us, because the word moral sounds strange in music, and it sounds strange in law. But we want Ms. Henderson, just touch on us what you understand by the term moral rights when it comes to copyright and music. Just briefly, very briefly.
Very briefly, moral rights just allude to rights that are not necessarily considered copyright, but are neighboring to copyright. In other words, they are associated with. So where the copyright rests in the author and composer, somebody else associated, like a producer who produces the record, would have a neighboring right, a right that is associated with, connected with the copyright. So they've been called moral rights, but they've been called in different terms in different jurisdictions. But moral rights, just because, morally, it's good for somebody who actually made a contribution that's not necessarily copyright protected to be included in the suite of rights that come with a work. So moral rights allow people like performers and producers and so on to have rights in a work, even though they do not have the initial copyright in the work. So that's what that is. I think I stand corrected if Miss Nesty wants to correct me or Mr. Murray.
And regardless of whether or not Miss Nesty or Mr. Murray wants to correct you, this is a very technical field. And the study of copyright and the protection of copyright and all the associated rights with it is very technical. And I know Mr. Murray wants to contribute to say something in relation to the moral right. So we're going to save that. We're going to make sure we stick up in, and we're going to make sure we save that term. Don't forget it, moral right. So Mr. Murray can weigh in on that at the end, right? I really want us to, I want to hear from your trilogy, but I want to touch on sampling culture. So so safe for me to move on, right? Okay, good. Sampling in Bouyon. And I can say that again slowly. Sampling in Bouyon. It appears to be a part of the culture, right? And for us, we adults, we understand what the term sampling means. But I need to understand legally, right? Is there any threshold, right, below which it is automatically permissible, big words, for a small island artist on a tight budget, right, to get access to a sample? That's a long way to ask, what is the practical process for clearing a sample? And I'm addressing that to Shelley, then I'm addressing that to Trilogy, and I'm asking all of you to stay as brief as possible. And if you see you want to direct the question to somebody else, direct it to Ms. Henderson. What is the practical process for clearing a sample in your experience?
Contacting the owner of the copyright.
Thank you.
And you mentioned budget, so I was going to touch on that quickly. That is really up to negotiation between you and that owner of that copyright. We're keeping that brief. There's a lot more I could say.
Yeah, but tell me how you find the owner.
Excuse me?
How do you find the owner of that right?
Internet. If you can find the song, you can find the owner.
Okay. Simple as that?
Yep.
Simple as
We
that.
most times sample popular songs, and any popular song, you can find out who are the people responsible for the master, because you sampling the tangible form of the music, which is the master, the recording. So that's when you contact the people that own the master. Yeah.
And you're saying you have to, or you ought to, you should reach out to the owner.
It is the right thing to do. This is not about morals.
Let's listen to this, please.
Yeah, it's the legal thing to do.
It's a legal thing.
Sampling without permission is illegal.
And I am going to take it, Mr. Trilogy, if you want to weigh in, you can weigh in right now. But if you feel satisfied with Mr. Shelley's answer, we can move on.
No, I'm satisfied. It's like he's a construction worker too, because he's feeling on the head, But I just like to add, like, if you try to reach, like, if the person is independent, you can go to them directly. But like you say, if there's an entity that owns the master, for example, a label, you can try to reach out to the label. And I can give a personal experience with that. When we were doing the song Rags, I don't know if people know, but Rags is a sample. Right? It's not a secret. And we tried to reach out to the actual people who had the song, the copyright of the song. And boy, months. So again, not just budget wise, but when you see you press for time, them things is not, it's not simple things. It takes a lot. And so for months we was trying to reach out until when, we could not even put out the version that we had for sale. We had to get somebody we had to tweak it and change different things in the actual song that we put out, so that we could, use it basically.
Use it.
Monetize it.
Okay.
Understand? So
no. With that being said, we got the direct, practical process for clearing the sample. And I want to ask a personal question to the three musical artists. If you don't want to weigh in, if you don't want to if you want to plead the fifth, as they say in America, you can do so. But has anyone on this panel had their work used, copied, or sampled without credit or compensation? Has anyone of you three, to the best of your knowledge?
Yes.
Yes? All right. So
Yes.
thank you very much, Ms. Henderson. And when you are answering that and you said yes, I need to know, without going into too much detail, If it's an active matter, it's an active legal matter, we cannot get into too much detail about it. But if it's one that has already been resolved, give us briefly what happened and what recourse, if any, did you have when someone sampled your music without sampled, use, copy, you know, credit, without giving you any credit or compensation? What did you do, and how did it turn out for you?
Okay, two things just to quickly brush up on the sampling thing. There's an agency called CSAC, which recently absorbed another agency called Harry Fox, which is, you know, responsible for a lot of the repertoire of popular music that we listen to. And so if you want to sample it, these are the people you need to reach out to, because they are publishers and also owners of the rights to issue licensing for a lot of these very popular, famous songs that you are looking for. So just so that the Bouyon artists recognize that. It's called CSAC, S-E-S-A-C. CSAC. Not like there's two CSACs, but that one in particular. And okay, to move on to my situation. This has happened to me kind of twice. One, when an entity used parts of my music, they used it in an ad. And I was obviously not too thrilled about it. It wasn't authorized. And so the matter was taken to court. And we did win a settlement. Although it was a tricky situation. It wasn't done exactly as we needed it to be done, but thankfully the law has kind of come around in Dominica a little bit more, and we understand better the procedures, so the next time I think would be a better situation. But we did actually win that case. And secondly, another time involved the actual CARICOM song, where in between registration, because I belong to two societies. I belong to ECHO and I also belong to SASEM. And in between registration, I had already registered the song with ECHO. And to SASEM, someone else had already preempted my official registration. I had already sent SASEM a preliminary document, but that person had gone ahead and registered. And so I was able to challenge that very easily. We didn't have to, there was no litigation involved or anything, but I was able to challenge that and provide my evidence that this song was already registered with ECHO, first of all, and that I had already sent in a preliminary registration with SASET, because you can do that. You can send a song that's not completed yet, but you've started it, and you can already send something like that to a CMO and get some protection. So that was the process. Everything was regulated, everything was resolved.
Okay. All right, thank you very much for sharing that. So it is important for the artists and the music persons involved in the music business to understand that there are ways to go about, you know, not just declaring your rights, but having or being recognized or getting credit or compensated for the work that you've put out. So Ms. Henderson just said that she arrived at a settlement in her matter, and you know, hopefully the courts and the rest of the public, the rest of the Caribbean seems to be far ahead, but then hopefully the courts here in Dominica get an opportunity to weigh in on, right. So yes, Mr. Shelley, you want to say something?
Yeah, let me see if I can also make this really brief as well. Personally, us at Signal Band, we do sample.
Yeah.
What we have tried to do a lot is, when we get to the point of really trying to exploit the idea of sampling that song that has then become popular, the Bouyon version, we try to then turn it into a cover. And a lot of the songs that we have sampled, eventually we made them into covers. We did Bob Marley, not Bob Marley, One Love, When, Menasio Fountain, other popular songs, and we have all purchased cover licenses to cover the song. So we get a female artist in Dominica. It has become like tradition now, you know. We like the task of engaging a female artist in Dominica that can really sing. I mean, bring on the Bouyon song and say, we want you to cover this song, and we as the band, we handle purchasing a cover license for that. So that's a way of doing it as well.
All right, no, so I'm hearing in the audience, persons are trying to figure out what is a cover.
You didn't have for the end? No, we didn't.
That's true. We'll leave that for the end, Miss Knight. So, Miss Knight, you and Mr. Murray, you'll have 2 questions. One on moral rights, one on what is a cover. So already we have 2 more questions that can be asked.
Mr. Murray is a master class and she's a question.
Thank you for that distinction. All right. Let's get into contracts a little bit. We spoke about it very briefly, but I want to understand, a little bit more about the deals, the rights, and fine print. Now, if any of you can assist me here, just tell me, what's the difference between assigning a copyright, if you know about, versus licensing your copyright? If any of you can share that information. Ms. Anderson, you want to be the one to talk on that? The difference between assigning and licensing?
But yeah, assigning is simply giving authorization to an entity or somebody else to to kind of have almost an ownership right, like you can assign rights to a CMO, for example, as an artist. So some of the rights you own as an author, you give to a CMO, so you assign them to a CMO so they can administer on your behalf, or you assign them to a publisher so they can publish on your behalf. That is what assignment is. Licensing, on the other hand, is where you get a fee for the use of your work. So, for example, somebody wants to use your song in a movie, you get a license, and they pay you, and they have the usage of the song or the work for a period of time.
Okay, I can accept that. I see Miss Nasty wants to weigh in a bit. I know we don't have the most time with Miss Henderson.
Okay, so just to, like Michael, just to provide some clarity on that assignment in intellectual property.
Bring the mic closer.
Music is the transfer of ownership of the copyright entirely. So in other words, the creator gives the right away, sometimes permanently. The license, on the other hand, it allows someone to use the work on agreed conditions. So the owner still remains the creator, but there are agreed conditions in which, for example, you grant your license to the collective management organizations. You don't assign your rights away, you're still the owner. But the agreed condition is that I'm granted the right for you to collect on my behalf. So that is the licensing aspect. And that distinction is very critical because many artists sign contracts believing that simply allowing their music to, simply allowing the use of their music, when in reality, they are assigning their rights away. So it's very important. It's very important to understand the distinction between these two.
Thank you.
So you have to pay attention to duration, territoriality, exclusivity, and all these things when you sign those particular contracts.
Get a lawyer.
That's what I do.
All right. I am mindful that we have to take some questions from the audience, and we have a time limit here. And I know that Ms. Anderson has to leave us just now. So let me see. I have 2 questions left for the panel, and then we'll move on. Trilogy, I come into you, and then I'm going to Shelley. How does a Dominican artist actually get paid when their music is streamed on Spotify or Apple Music? And I'm asking you this particularly, if you don't know the technical work behind it, fine, you can refer it to management. But tell us, please, because you said your work has hit the billboards, your music has been in Ghana, etc. We know we can get your music on Apple and so on. How do you get your money? How do you get paid when it gets onto that platform?
Well, I think it's simple. The platform, when every time you stream, you get a percentage, which, quite frankly, sometimes feel like a very small percentage.
But a percentage of what? Tell me a percentage of what?
You get a percentage. So basically, every play has a value, right? So it have a value every time somebody play, or if let's say they download your album, they are the ones who are basically, if you want to say it for, like the term I feel is publishing. So they are the ones that, not publishing, but distributing.
Distribution.
Yeah, distribution. So that implies an important word. Apple, Spotify, all these things, Amazon Music, these people distribute your music for you, even on YouTube. Yeah. There's a tool that we use. Well, I think Michael mentioned one that she uses, but there's DistroKid, there's TuneCore, there's these platforms. Yeah, these platforms, they are the ones that send the music to Apple, Spotify, and the different how you say it? Why you calling it Cherry? Like, why you calling
DSP, Digital
DSP.
Streaming Platform.
Yeah. So anytime you see your music gets played on these platforms, as the artist, you get a small percentage. A small percentage because the distributors really absorb a lot of cost when they do those things. I would assume.
Because you get such a small share.
Yeah. Sometimes you have to get 1 million plays for you to see your way, you know, that kind of thing. But at the end of the day,
that's part of the business.
Only little bit coming up to make a big bit, you know.
That is it. I see, Shirley, you want to say something?
Yeah, I wanted to add that the first step is you have to register with one of the digital distributors, because, you know, as artists we don't have, you can, but we don't have the direct access to Apple Music, to Spotify Plus. In 2026, that would be too much, you know, for a Gen Z or millennial to do. So we just send that to one place, and we say, hey, I want you to send this song out to the stores. And similarly, you're allowed to enter splits. You can say, I want to send 30% to Trilogy, I want to keep 70, or I want to share it to a whole other people. And similar to Mikel's distributor, they just send the money directly to that person, and poco.
I see your colleague.
Which I'm glad Shirley bring that up, because that is a question I had earlier, and then we had to like move on. But I really want to touch on that, and I guess people that are more inclined to the law, like Mikel and Miss Nesty, can probably touch on that in the apps. I mean, I know we talk about moral law and moral rights and everything, but apart from that, like, you know, if you have a split sheet that, let's say you don't have a physical split sheet, but you did make the split sheet on the distribution platform, is that something that could necessarily, like, you could utilize in terms of, you know, saying who has
what share
and who has, yeah, right? Because these platforms do provide some kind of split sheet, you know. So that's my question.
Yeah, well, you see, I take it that even if you ask the question, you answer the question.
No, whoa.
No, because
that's a different to be. The question he asks is a little bit more specific. It's whether or not you can use that particular split that you use with the distributor
as your split,
as evidence of a split that you did not do before putting it up on the. I think that's the question, right, Chula?
Yes.
Right. So essentially, well, from what I understand, essentially, remember your split sheet with the distributor is based specifically on your master. It's based on who owns what part of the recording, but that does not apply to your initial copyright, because it's just that the distributor does not deal with your copyright, they only deal with the recording.
Right, but I'm saying in the absence of the copyright.
Well, remember we established a little bit earlier, it's hard to say you. That
might be probably in a cause of action. That might be evidence that you can say, well, if for example, this was used, you might be able to argue that would have been what the initial understanding. You know, in law, they really have to seek the intention of the parties. And so when you look at something like that, that would speak to the intention of the parties. But it's not concrete evidence that is exactly what applies to the actual copyright of the actual song. So, because you could make as Shelley said, you can make a different agreement with a producer or with somebody else, you know, concerning the master than the agreement you have concerning the song itself.
I think that would go, in addition to what Mikel just explained, I think that would go to the calculative of your economic rights as to the copyright you have entitlement to for your master, but it wouldn't give the overall economic attribution to everybody who created the song. Because remember, at the end of the day,
we cannot hear you.
Sorry. At the end of the day, if you want to claim, should I repeat? I'm saying that would not have given you the opportunity to establish your whole economic rights. So it will only be established through the elements of your master. But as it pertains to the composition, because remember, your copyright is for your economic gain as well. So at the end of the day, that aspect of it will not be calculated, because for you to gain what is truly yours, just like financial elements, you have to, what copyright does is that you have to follow the money. So where the individual made the money, you have to follow the money to see where is your money. And in order for you to establish right,
We'll speak about it later on.
Alright. Well, like I said, Miss Henderson, I know you may have to step away, right? And Trilogy, you wanted to say something fast, but I want to...
No, I finished.
You finished? Alright, so Miss Henderson, let me start with you. If you could send every young Dominican musician home with some homework, one action they should take this week, not tomorrow, sorry, not next year, not 5 years from now, not next month. If you could send a Dominican musician home with some homework in relation to protecting the musical work, what would that homework be?
Tonight, 5 minutes from the time you end this broadcast, you need to go and investigate a collective management organization that you can sign up to help you protect your rights. Okay, it's the most standard way of protecting your work. It is internationally recognized. The systems are already in place. You do not have to reinvent the wheel. So as long as you've had a work that has already been published, because that is a usual prerequisite to be registered, is that you've had at least one work that has been published, and you become a member and you register that work, and then everything else is just a matter of declaring each work that you do as time goes by. That is one. Number two, please investigate all the various digital platforms, because music is going into, I know our law specifically talks about tangible fixation, but in the digital era, and we're going to have to extrapolate that tangibility to digital works as well. So right now, digital distribution is the way to go. You need to investigate the various platforms like CD Baby, like DistroKid, Believe Digital, and all these. And there's a new one called Sound Exchange. It's not it's not new, but I'm not sure a lot of us are exposed to it. Sound Exchange is a platform that allows you to collect royalties from your music being played on digital radio. So we're not talking about AM or FM radio, we're talking about XM radio, like Stingray, for example. Music that's distributed through online platforms. So you have radio stations that do just that. So Sound Exchange is another platform that you can benefit from, and there's a lot of Dominican music already in this Sound Exchange repertoire. So I'm telling Dominicans, go there, check it out, sign up, and look to see if your song has been played on digital radio. The royalties might be waiting for you just to sign up and collect it. So make sure you do that one.
Very important, and those were two action items from you. Now I want to end off with Shelley, because Shelley is going to have to answer Miss Knight's question on cover. So I'm going to go to Mr. Trilogy. What is the one piece of homework you'd send a Dominican musician home to do this week?
Well, after today and knowing what happening this week, get a lawyer.
Very good answer, very good answer. If I didn't say so myself, thank you very much. And Ms. Nesty, on your end, remember you are speaking to us as the registrar of intellectual property. What would you tell a musician, a Dominican musician, to do right now, if they can, to protect their music?
Okay, so I'll speak to them as an attorney at law, because registration of intellectual property does not form part of the intellectual property office. I'm sorry, of copyright. So it's very important that you treat your music like your business, because that is your profession. So ensure that you know all the elements of your creation and the rights of your creation, and ensure that you protect those rights, because each and every one of us have professions, and that is your professions. Your music can be your collateral, because you gain from it even after you die. You can will it, you can leave what is entitled to others. So ensure that you treat your music as a business, and ensure that you know all your rights, your obligations, and as Trilogy said, seek legal advice.
Seek legal advice. So technically, treat it like it's a piece of land for the musical artist. Your musical work is your asset, so protect it as a business. Very well. Shirley, I come to you, and you know, after you answer that question, we're going straight into Miss Knight asking her question to you. So what would you send a Dominican musician home to do tonight in relation to protecting his music, his musical work?
I send them to learn, like just educate. I feel like you have, before you can make any step and start registering, and you have to really, it's a lot of technical jargon, and it's a lot of
It's a lot.
technicalities, a lot of minor differences between certain things that can get you in trouble. So just go and learn, like you're really trying to become an expert as much as possible about it, because it is a business.
Yeah.
And then to tie in trilogies as well, if you don't understand something, then you get a lawyer. Not to say that if you understand, you get a lawyer too, because I understand and I have a lawyer.
Ignorance doesn't pay you.
Yeah, ignorance doesn't pay at all, and yeah, that's it.
That's it. All right, Miss Knight, you can go straight into answering your question of what is a cover.
Yeah, so a cover is a performance of an existing song. A cover. So I was saying that usually when we take a song, for example, Nasio Fountain When, and we want to make a Bouyon version of that, we don't want to just take the audio recording of Nasio singing. We say, okay, let's learn Nasio's song and take the composition of it and let somebody else sing it. I, Shelly, or another artist, we bring it to the studio and they perform it. So pretty much they are now covering, cover becomes the verb now. They are covering Nasio's song. But you have to get a license to do that. And the license is not me calling Nasio and saying, hey bro, I want to do that. The license is also me going through a distributor. Well, we have done it digitally. It's easy these days. You just go on some song licensing.com, or they have different platforms where you can buy a license for a song to cover it. And that's what we do for all the works of other people that we have on digital streaming platforms.
Very well. And that safeguards you against unwanted, headaches when it comes to people come to claim. Hopefully. Hopefully. All right. Mr. Murray, I know, like Shelly said, you have a master class to issue to us on moral rights, right? Because it's a term that is used, and it's a term that is usually misunderstood. So I'm going to ask you to just touch on it a bit. Moral rights. Just define for us what is a moral right, and how is that associated or part of copyright. And while someone is getting the mic, while someone is getting the mic to Mr. Murray, I want to let the audience know I'm trying to take 2 other questions. So if you have any artists or anybody else here that want to give 2, 3 questions or whatever in relation to musical management, music business, and you want to direct it to any of the panelists, prepare your questions. Mr. Murray, you have just about 2 minutes to just touch on quickly what is a moral. I'm not hearing you, so bring the mic closer.
Since there are many lawyers here, and I assume everybody studied some history, they should know that the first copyright law was established in the United Kingdom in 1709. It was intended to protect publishers, that is to say, people who take works from authors and commercialize them. That was its intention. So therefore it was based on economic considerations.
Yes.
In 1789, I think most people know what happened in Europe.
No, we don't know what happened in Europe.
Revolution.
Yeah.
The French Revolution set out in 1791, the revolutionists.
Yeah.
Robespierre and his Danton and so on, and friends.
And this is the introduction to the moral right.
To put an intellectual property law in place. And it was intended to protect the creator of the works specifically. Therefore, there are 2 systems of law in the world that dominate the world. One is the common law system, the other one is the civil law system. There are more countries follow the civil law system, and which is basically a lot of it done in France, from Rome and Italy and so on, blah, blah, blah. So, in France and in civil law countries, the protection is called author's rights rather than copyright. So it's based on the author. And the intention of law in the civil law countries is to protect the author. Therefore, they come to say the moral rights of the author. That has nothing to do with morality. Your totally immoral song, you have immoral rights in it. And the moral rights are the right to have your name prominently associated with your work. 1, in any public use of your work. 2, not to have a work that you didn't create falsely credited to you. 3, to use a pseudonym of any sort that you like. 4, to publish your work anonymously if you like. And 4th, or 5th, wherever it is there, not to have your work mutilated. For example, if you buy a painting from early 18 and you find, this thing over there should be a little bit more blue, you, although it's your painting, you bought it, you have no right to go and put it in blue. Okay? If he finds that out, he sues you for mutilating his work. And you get a big fee. Right? So, that's what moral right is. It protects the integrity of the work and the author who does the work. Right?
Yes.
That is what it is. So there is no financial gain just from your moral right. Only financial gain. You will get the visits infringed, and then you get damages paid to
You bring a claim against somebody.
And in the United States, there are no moral rights except for painters, people who paint stuff.
So there's no moral rights for musicians.
No, we had to go back. The WTO discussions was about trade. Part of the WTO agreement has a section called TRIPS, and has to do with trade and intellectual property. Yes, so it says that everybody who wants to be in the WTO must join the Berne Convention. The Berne Convention, Article 6b says everybody must have moral rights that protects blah, 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 blah. In the TRIPS agreement, the American got them to say everybody must join the TRIPS Berne Convention that talks about that there, but accepting Article 6b because it's not a tradable right. So, in the United States, music has no moral rights attached to it. So, for example, I'll give you an example. There was a time when colorization of black and white films were popular. And the Americans got away with that thing about no moral rights by saying, well, moral rights is a kind of defamation, and therefore our laws on defamation take care of that already. So if you think your moral rights are infringed, sue for defamation. There's this guy called John Huston.
No, that isn't that's America, right?
Yeah.
Right,
in America.
Okay.
So if you go to America and sue for your moral rights, you will lose the case.
But if you try to sue for your moral rights in Dominica,
yes,
you are likely to.
The very same case that you can't sue for in America,
you can sue for
in
it
Dominica,
and get
because our law happens in this particular case to follow civil law tradition. And our law in Dominica and in Trinidad very much the same. Matter of fact, on the moral rights thing, they would for the same.
So that's Dominica and Trinidad.
Yeah.
All right. Well, I know with Mr. Murray, we have. We must wrap up just now.
It's important that the moral rights are intrinsic and very.
It's very important that they understand.
Very necessary for people who create works because they have an attachment to their work.
I see.
Yes, so it's not a money-making thing, it's a respect.
It's a respect for the integrity of the book that is created. Okay. Thank you for that. So I am going to invite everyone when we have a refreshment stage, I would advise everyone to, if you get a chance, to reach out to Mr. Murray and ask the questions, because he does have a wealth of knowledge when it comes to copyright law. Understanding the history, understanding the development of copyright law, and also understanding the application of copyright law. All right, but now it's time for me to take 2 quick questions because we're supposed to end at 8. And Michael, I know you're supposed to leave my desk, so thank you so much for staying still with us. All right, we appreciate everything that you have given us, your contributions. And if you must take your leave, you can go. But if you can just stay, please, just for the 2 questions, we would love that.
Okay, quickly.
All right. All right, so I see we have a question at the front. Does anyone, any of the well, we have 1, 2. Wow, we have 2 questions already. But are there anyone? You need to stand, at least tell me your name.
Ronald Knight.
All right. What is your question?
So my question is mainly to Mikael. Do CMOs collect in a particular currency? And if they do, how do they deal with the fluctuation of currencies? And how do they also deal with the blacklisting of countries? So not every country can distribute money to another country, if you understand what I'm saying.
I am not familiar with any issues that CMOs have pertaining to currency. For example, each CMO kind of works within its own jurisdiction. So the Eastern Caribbean Collective Organization for Music Rights, ECHO, would deal in Eastern Caribbean dollars because it's an Eastern Caribbean organization. So it doesn't collect in any other currency, to my knowledge. And they would remit according to what the rate would be at the time that the remittance is performed. That is how I would, to me, that is just a general, layman's understanding of how that process would work. There are, as Ms. Nesty alluded to, there are bilateral agreements, there are reciprocal agreements amongst the CMO, and so I don't think that any of those are hampered by or hindered by the idea of not being able to send money to another country. I'm not familiar with that process at all, but to my knowledge, there hasn't been any issue with paying monies to the respective CMOs as long as they have a reciprocal agreement.
And I'm hoping that answers your question in relation to being blacklisted as well. Yes, so we're going to take another question from the audience.
I'm afraid my question is
I would love to know your name, my dear.
Sorry. I'm afraid my question might be a little bit...
Who are you?
I'm so sorry, excuse me. I'm Barbara Bully Thomas.
Thank you very much.
A singer-songwriter. And I really was hoping tonight that we'd be talking about what has happened to music with AI. Because everybody knows that AI is out there.
Yeah.
And I thought that was so important that we should discuss
AI.
how you copyright AI. And I was told when I called ECHO in St. Lucia that you can use AI any way you want to use AI this time.
Yeah.
Because AI, first of all, cannot copyright anything because AI is not human.
Yes.
Only humans can copyright.
Yes.
So everybody's free to basically, like I have a couple songs, I have the originals, I put them in, and AI sent out this fantastic reproduction. And I called ECHO and said, well, now I have two versions of one song. What do I do? And they were the ones who said to me, you have to copyright this one as well. You have to copyright your AI version, even though you've already copyrighted the original with us.
Yes.
Because it's still yours.
It's still
your lyrics, your melody, and they put in the music.
Your
so it's
input.
yours.
Yes.
And
yes.
even other people have told me, one friend told me she has 70 AI songs. So what did you do? She said she goes to the Bible and she gives them a phrase from a psalm and they make a song for her. And so AI is coming in. So we want to know now, what's going to happen when people can just go in and make songs freely and put them out there and say, that's my song, because I made a song out of it. And we have to discuss AI, because AI is here to stay.
I am grateful for your question, because I can admit in the preparation for this discussion, myself and Mr. Murray had to face that topic, AI. What is the space AI is taking up in the music business? And I want to say, let's leave that for the refreshments conversation, because it's a bit... No, everybody wants to know? Yes. No, I'm letting everybody know that Mr. Murray, like I said, is the one that is going to have to answer this question. If the panel can, it's open to them. But because I know that the copyright legislation somewhat touches a bit on computer-generated work, right? And Mr. Yeah, I don't want, I'm telling you that the Dominica legislation does make some sort of wide provision for AI or computer-generated musical work. All right, so I'm going to hand over the mic briefly again to Mr. Murray, so the public can understand the role of AI, or at least how you can protect your music in this age of AI.
Okay, here it goes. It depends on which country in the world you are. The United States, the way their law is written, it's interpreted to say only human beings can create works in which copyright exists. However, it also says that if you and the computer create a work then you have copyright in the section that you created. For example, there's a very popular song, I think it's #1 somewhere in the world there, that was created where the music is played by a computer, but the lyrics were written by a human being. So the human being has copyright in the lyrics, and there's no copyright in the music that's played by the computer. If you're in Dominica, the United Kingdom, and so on, the thing says a computer-generated work, there's a definition actually, is a work that's created in a condition in which a human being cannot be said to have created it with a computer. And it then goes on to say the owner of the copyright in that work is the person who caused the computer to create the work. And the length of duration of protection for that copyright work is 50 years from the date of the creation, rather than life of the creator plus 70 years in other works. Yeah. So in Antigua, actually, they have a very confusing thing, because they say copyright belongs to authors. No, it defines authors are natural persons who do this, that, etc., etc. But then it goes on to say define a computer-generated work, in same as in Dominica, and then says that the computer-generated work, the copyright belongs to the person who caused the
work to be created.
Right. But that is in conflict with the statement that the author is a natural person.
Yeah.
Computer is not a natural person, but so therefore it should not have copyright. So there's a kind of confusion in the Antigua law between.
Yeah, but allow me to just give a definition according to our Copyright Act of what computer-generated work means. And it means work which is generated by a computer in circumstances in which the work cannot be said to have a human author. That is it, and that is all. That is very basic, it is very wide. And I don't know whether or not yet the courts have come across any kind of copyright matters in the Commonwealth of Dominica, but I would love to see that happen. And again, just to reinforce the point that Mr. Murray was saying, in our definition section in the legislation, it defines an author as well. So an author means a person who creates a work, being, in the case of a literary, dramatic, musical, or artistic work, which is computer generated, the person by whom the arrangements necessary for the creation of work are undertaken. So even if you put into AI, you are considered the owner or the author of that book. All right. So
can I ask a quick follow-up question, please?
Well, okay, but we're here, we're asking questions. Let's go, Ms. Anderson.
Very quick. What if the creator is in Dominica, but they're using a platform that is specifically from another jurisdiction? Which law, which situation applied? Do we apply, let's say you use a US-based AI platform to make a song, but from Dominica?
Again, I want it to be known that these questions that have been asked, they were directed to someone who has in mind.
Mr. Murray.
Well, quite frankly, it wouldn't matter, because if the law says a computer, it says nothing about where the computer is. Okay?
So the legislation in Dominica covers that for you, Ms. Henderson. Computer generated. It doesn't matter about the software. It just says computer generated. Right. So.
Okay, thank you.
Well, hold on. Ms. Knight, you're asking a question. I cannot hear the question, Madam President.
My question, I suppose it's a technical question. If something is produced by AI, by artificial intelligence, is it the computer that's creating the work? Because the computer is a physical thing. The AI is the software, it is something much deeper than just a computer.
Madam President, I'm going to advise.
That's cocktail.
Yeah, that's cocktail discussion. No, that question is cocktail discussion. Because I have my view, and I'm sure the panelists themselves have their view. So, Minister Murray, we will continue this conversation.
Just to clarify there, if you use the thing properly and you pay for it, the computer company or AI company gives you a license to use it any which way you want to make money. So if there's any confusion about whether you are entitled to use it or not, it's clarified. So the computer company says, AI company, Sudo, which is the probably most popular one, says they give you a long license and so on, and what you can do with it. If you are a paying customer, if you use the free version, you don't have the right to make commercial use.
Mr. Murray, we already encourage the audience to have this conversation over cocktails. And it is because, like we said, the age of AI cannot be avoided, and where we want music to go. All right? And I know Miss Nesty wants to give her final point, because we have snacks waiting outside for us to eat. All right?
Okay, Heather, so I know that you may be very hungry.
That's right.
So just to answer your question as to artificial intelligence, it's a growing area in intellectual property. So a lot of the elements, it's a growing area in intellectual property. So it's a lot of the areas are not fully understood. But the basis of it still lies on the premise that the law speaks to a person, a person, a person, a person. So AI is not transferred or given any rights at this time, but the law is developing slowly as it relates to intellectual property and artificial intelligence. So it will treat AI as a tool. So that is what you're using, a tool. So you're placing your intellectual property and your lyrics and everything into a tool. So ultimately there are certain elements, if the tool now sings for you, then who owns that property? You still have your composition copyright, but as to the song recording and all these things, there's still some very varying elements, but it's a growing area, and as soon as we get more cases decided and more regulations, it will be structured in such a way that we will fully understand.
All right, so I'm going to put an official end, Mr. Murray, to the panel discussion, the formal discussions inside here. And I want to preempt, or at least I just want to say thank you as the moderator to the panelists for sharing the information, and thank you to the public for tuning in. And of course, thank you to the Dominica Bar Association for raising this topic on how we can protect our legacy in music as Dominicans. I know, but we will discuss it as soon because we have time. We have a time limit with these two lovely camera guys and our recording, and also the use of this lovely space. So we're going to hand over to our MC, Miss Knight. I can.
Thank you very much, Kalita. We have a formal vote of thanks, so I will call on Miss Jody Luke to deliver that vote of thanks.